Hi, everyone. I'm Tyler Bugg. Thanks so much for being here. On behalf of New America and ProPublica, we're thrilled you've joined us this evening. Just a little context. A week from today is the 50th anniversary of the signing of the Freedom of Information Act. So we are thrilled to be partnering with ProPublica this evening to host this discussion on the past, present, and future of FOIA. As many of you, I'm sure, know, ProPublica has been a major leader in pushing for various iterations of FOIA reform, so we could not think of a better partner for tonight's conversation. A couple of housekeeping notes before we get started. We are live streaming and recording tonight's conversation, so I'm going to ask you to please refrain from flash photography. And also, just give you a heads up that we're going to have an audience Q&A portion. And once we get to that portion, know that in asking a question, you're consenting to being recorded and live streamed. And number two, we are hosting a little wine reception at the end of tonight's conversation. So we hope you'll stick around, have a glass of wine, and mingle with some of the speakers more informally. So without further ado, leading tonight's conversation is the genius Steven Engelberg. Steve is the editor-in-chief, as you know, of ProPublica. He was managing editor before he became editor-in-chief, and also has an illustrious investigative reporting career for the Oregonian and the New York Times. So I'll do no more bragging and just turn it right over to him. Thank you all so very, very much for being here.
Thank you, Tyler. I will not protest too much, but I think genius is a little over the top. I'd like to introduce our distinguished panel tonight and say that it is very exciting to be at a FOIA session with such an optimistic title, Access Granted. I participated in a few of these gripe sessions, and they are that. So I hope in the spirit of our optimistic title that we'll be able to deliver you, in addition to gripes, some interesting insights and tips on how to use the law better. To introduce our panelists, we have Brett Max Kaufman, is a staff attorney at ACLU's Center for Democracy, where he works primarily on national security issues, particularly on ones that are FOIA relevant. He also teaches in NYU's Technology Law and Policy Clinic, and I learned moments ago that he's an eternal optimist. He's a Cubs fan. Directly next to him, I guess we've divided up by journalists and lawyers here, is Rebecca Williams, Senior Implementation Advisor with the Center for Government Excellence at Johns Hopkins University. Before that, she was a Senior Open Government Analyst for the Federal Chief Information Officer and worked on the information and transparency projects, including data.gov and for the Sunlight Foundation. Then we have Talia Buford, I'm sorry, see, I should have flipped that thing. Talia Buford, who is a reporter for the Center for Public Integrity's Environment and Labor team. Before that, she was an energy reporter for Politico and a legal affairs reporter for the Providence Journal. And then Sarah Cohen, reporter and editor at the New York Times, where she leads the Computer-Assisted Reporting Group, a unit of data journalists that specialize in reporting complex stories using data and document mining. She came to the Times from the Washington Post, and she is the board president for the Investigative Reporters and Editors. Welcome all. So I thought I might just kick it off here a little bit. I was looking around at the question of what people are saying about the 50th anniversary of the FOIA law. So it turns out that the AP did a fairly extensive analysis and investigation of FOIA statistics, and their editor, Ted Brittis, published a story in March, which you can all read, and he was interviewed recently by Neiman Laboratory, and he had this to say: the Obama administration even now continues to portray itself as responsible and transparent when it comes to government records requests. It has become unarguable over the last 7 years that they are doing a lousy job. They had said all the right things, but when it comes to practice, when the rubber meets the road, it's just a horrible situation. So we'll start with you, Brett. Fair, unfair? What do you think?
Is this on? I would say fair. Especially in my field, which is mostly national security work at the ACLU, there's certainly a mixed bag. At the outset of the administration, President Obama made public the torture memos, of course, and that was a huge moment for transparency. He also released a bunch of other documents associated with the torture program under President Bush, but I think President Obama's found it much harder to release information that implicates his own presidency, especially when it comes to targeted killing and NSA surveillance. And so while there's been some progress on those fronts, he has taken a pretty hard line, and I think the statement's pretty fair.
What do you think, Rebecca?
As somebody that used to work for the federal administration, everything I say is not a reflection of the federal administration. But I guess I feel like, of course, President Obama's in charge. He's the boss. But when we saw everything come out, like the DOJ backlash to the FOIA reform, my suspicion, again, not reflecting my professional experience, is just that the federal government is so many people. There's so much autonomy that each agency has. A lot of the times everything gets wrapped up in the Obama administration. These are the folks he put in charge, et cetera, et cetera. But I think there's a lot of folks that are in agencies to begin with that have they've been there a long time before he was the president, and they have some sort of say in it. Not that I'm like satisfied. On the other end, President Obama has been pretty progressive in terms of trying to push some of the open data, which is like the softer, structured data cousin to FOIA, policies along the way. And those things could be a lot stronger. And I'm concerned about like our future president in November, how any sort of candidate is going to play out in terms of like wanting proactive access to like structured information. And he's done these other things on the other side, but of course he's ultimately responsible. But I guess I feel like there's a lot of actors responsible.
All right, Talia, you've worked in the field of trying to open up some data. So why don't you tell us a little bit about what you did and how it went?
It usually goes very slowly for the most part. So most recently, we did a big story on the EPA Office of Civil Rights and their enforcement of Title VI. And we FOIA'd all of the complaints that people filed, the protest letters or the adjudication letters, and just basically anything that EPA had on a particular case that someone filed. We filed that FOIA in May of last year, or in 2014. I came on in November, started working on the FOIA. They said that the last of the data would be released in December. They sent us a document, or a disk. It was missing maybe 30 to 40 documents that we were waiting on, that we had a list of. It took us from January to June for them to just say, hey, here are the documents that we said we already gave you in December, and oh yeah, by the way, the stuff that we said that we were going to give you, we're not going to give that to you, because we had negotiated with the FOIA officer who was working with us to get a little bit more, and he left in the meantime. And so we had, like, they just didn't honor that agreement, so we had to file another FOIA for this like small bit of data that they could have just thrown in. So they were like, you're already working on this, like, getting this data for us. Can you just give us these like 2 years with 5 cases? And they're like, no, not today, not today. So it just was very frustrating. Like, I had a contact there who just would not email me back. There were simple questions, like things that I thought were simple questions, like, hey, there's a discrepancy I see between the information you have on your website and the information that you've given us in these files, and I'm trying to figure out which one is accurate. Can you tell me which one to use? And radio silence for months. So we eventually just went ahead and said, okay, we're going to make our own decision, and this is what we're going to use, and this is why, and just kind of explaining that to the readers. But it was very frustrating to have things that you felt were very, very simple take months or weeks to get an answer. And so even though we had filed a FOIA, and even though the FOIA, they were responsive to the FOIA, it was very, very difficult to just kind of get the final information.
So do you have any tips for what to do other than launching violent attack or spamming people on Twitter? What is it that what's practical that actually works?
Well, so I don't know if it's practical for everybody, but since I'm an investigative reporter, literally all I have to do is this one story. So I have nothing else better to do than call you all day and email you. So I tell people that, like, no, I'm going to keep calling. And so I just would call them every day, or I'd set a little alarm, like if I went and did something else, and I'd say, oh, haven't called the EPA today, let me call and email, and start CCing their boss and their boss and their boss and their boss, and just keep going up the chain, and then just eventually, like, emailing everyone all the time whenever I sent any sort of email. And I'm like, there's no way that this request got lost. There's no way that you didn't know that I was looking for this information. And I'm also calling you every other day. So I just did that, and if nothing else, they knew who I was. So.
On the plus side, tell us a little bit about what emerged from all this work, because, I mean, your story sounds very frustrating, but on the other hand, you got some very good journalism out of it. So, I mean, the law did work in the end.
Yeah, it did. What we found is that, so Title VI of the Civil Rights Act is the law that basically says that anybody who gets federal, financial, or any sort of assistance can't be discriminatory. And so what a person who is of color can do if they have some sort of environmental issues, they can call EPA or file a complaint with EPA and say, hey, there's a problem. I think I'm being discriminated against. I think that this facility or this law is impacting me differently than it would someone who is not of color. And it also applies to sex and religion and a couple of other things. But so what we found is that in the majority of cases, EPA dismissed the complaints outright without doing any investigation. And even for the ones that they did investigate, there was very rarely any sort of actual action taken by EPA to fix these issues. And so these are people who are living next to toxic waste facilities, or even some cases, the complaints had been pending for literally years. Like there's one case that's been pending for 14 years, I think. And that was a case of the residents there wanting to have certain documents printed in Spanish. And so it wasn't even, it's something that we all see as very common now, but at the time it was not. And so it was a fight that they started to wage, and by the time, well, even now rather, the state has already started to make that a standard practice, and EPA still hasn't ruled on whether or not this is an issue or not. So we found those things, which was great. It just took a little bit of time to get through it.
So, Sarah, I think it's fair to say that, you know, this administration's FOIA policy, it was not your first rodeo. You've been at this a little bit. Talk a little bit about kind of, you know, looking at the larger context of this over the years. How has it changed, and what, if anything, has gotten better?
Well, certainly information, documents, data that the government wants you to have are really easy to get now. And so I think that in the larger run, every administration holds information more tightly and views it as more control, and they use it as a way to control the message. And every administration controls the message better than the one before. So what we've ended up with is a lot of FOIA officers and a lot of actually pre-FOIA will talk with other officials or the public information officer. There's no benefit to them in terms of releasing information without explicit instructions that they should. And of course that turns FOIA on its head, because FOIA means that we have a right to documents. These are our documents and data. The government has to make an argument to keep them secret. Instead, we have to make an argument to make them public. And each administration holds that information tighter than the one before.
So I'm still looking for sort of, you know, glass half full.
Oh yeah.
So tell us something that's worked and how you did it in the last during this administration.
It does work, and I think the big thing that has changed is that it really is a lot easier to get information that there is no objection to you getting. So you can spend your time fighting over the ones that there are objections to. But we do plenty of stories where FOIA actually works. One with your own staff member, Ginger Thompson. We were able to get a database of every immigration removal and deportation and analyze it to see the Obama administration's performance on that. We got that I think it was 2.5 million records. I think we got that in a couple months, which is not bad for FOIA. If you're really specific and you know what you're looking for and you're able to spend some time, it works sometimes. A difference from Talia that we have is that we have a great legal office. And I was on a panel with our attorney, David McCraw, not long ago, who is very, he's very willing to sue whenever he thinks it goes too far. So if we just don't get an answer, he'll sue. And the way he puts it is that for $200, you get to go on the top of the heap and you get a real FOIA officer who knows what the story is. And that's what the filing fee is. But there are some other things that have improved. The Office of Government Information Services can be a great deal of help in terms of shaking loose documents like the ones Talia was talking about. So it's not entirely hopeless.
Trying to avoid the
echo.
feedback by turning mine off in between. So Rebecca, you have been on the inside, and for those of us who have lived on the outside, we have a, shall we say, an image of how it might look. Bunch of people laughing, sitting around with beers in their hands, saying no, no, no. I'm assuming it's not really like that. So can you tell us a little bit about what it looks like on the other side of this with these, requests, coming at you every day, and hundreds of millions of potential man and woman hours? What does it look like on the receiving end?
Sure. So I had the pleasure / struggle of sort of going into the federal government with a bunch of quote-unquote change agents. So like a bunch of my colleagues at the Sunlight Foundation also joined the feds at the same time. A bunch of journalists also joined this outfit called 18F and General Services Administrations, like Jacob Harris from the New York Times, Melody Kramer from NPR, a variety of journalist folks. We had a NICAR panel about this. And I think I can summarize our collective experience as just being sort of surprised that it was more of a mess inside than we had anticipated, or that old saying about don't attribute to malice what can be explained by, is it incompetence, whatever it is. But the fact is that when you're inside, I thought when I was inside the government everything would become clear to me, I would gain all this knowledge. That's part of the reason I did it. Nothing is more clear. There's just more and more black boxes inside black boxes, and in fact it makes your job as a federal employee very difficult. So from the inside, I think I only had to answer a couple of FOIA requests directly, and they're all open data related FOIA requests, so they're, benign, not scary. But I remember getting them, and they weren't narrowly defined enough, so I couldn't, if I wanted to give everything I could, which I ended up doing through the approval of attorneys and my managers. It was not hard to do, but I had to want to do that because people don't know what to ask for because that's how FOIA works. So the issue with FOIA is that it was created in a time with filing cabinets, and then also that you have to know what it is to ask for it. We have glass half full, positive things about the world right now. We have all this technology, we have the internet, we have ways to automate this so that you can envision a world where sort of not only can the agencies talk to each other with their data, not only can the data be secure, the information be secure, but we can use email APIs and all these structured tools to sort of proactively file things where they should go, and then also just put things online instead of you having to ask for it, or have a list of things so you know what to ask for. And this just wasn't a possible thing when FOIA was originally created, but is a possible thing, but very, very hard to do right now.
Well, that beautifully segues us to the next question I had, but I don't want to put you on the spot, Brett. The question I will ask, which I know you'll have an answer and thoughts on, is what do we think of the recently passed laws? Does it really help things? But I'm just curious, because why not? I'm the moderator, I get to ask. I don't actually know what was happening in 1966 from the legislative perspective that caused our Congress to pass this law. Are you familiar with the legislative history?
Yeah, well, some of the history is tied up with the Church Commission, the Church Committees, who had investigated NSA surveillance, CIA surveillance, FBI surveillance of political activists and other Americans, real abuses of the surveillance powers that the government had at that time. And in response to that, Congress got to... I went out here. Congress, including a young Donald Rumsfeld, got together to pass this law to allow access to government documents so that something like this wouldn't happen again. I mean, the reasons behind the law are fairly obvious and fairly commonly known by now. One particular purpose of the law was to eliminate what's called secret law, so that the government wouldn't be able to shield it's operating legal theories from public review. And that's especially important in the areas where I work, where because of other judicial bars to accountability kinds of lawsuits, you often will not get your day in court with the government, and courts will not oversee certain kinds of programs. For example, a few years ago at the ACLU, we brought a lawsuit on behalf of the family of Anwar al-Awlaki and his son, Abdul Rahman. Both of them were killed in drone strikes in Yemen. And his father came to us, and we brought a lawsuit with the Center for Constitutional Rights. But there were many, many obstacles to actually litigating the case. We actually won one that is very infrequently won, called the political question doctrine. But there's another doctrine called the Bivens doctrine that meant that we couldn't have our day in court. There's also many kinds of immunities, both official and governmental, that prevent the law of something like the targeted killing program from being litigated in an Article III court. And that is effectively what we had asked the court to do. We said the government is running an execution program from the White House, and a court should weigh in on whether it's using lawful and constitutional standards. And the courts backed away from that. So especially in that area, FOIA should be a really important tool to prying that loose. And it's right there in the law. Section 552A, it calls for the government, without a request, to disclose the government's effective law and policy. And the Supreme Court 40 years ago said that means that when the government is using a legal memo to make decisions that affect individuals, it has to disclose it without even anyone asking for it. Unfortunately, that's been one of the most abused parts of the law. The government rarely, if ever, affirmatively discloses something under that provision, and they often claim crisp-cutting exemptions to protect law in those even purely legal memos in these sensitive contexts. And so that is definitely, and obviously this is the area that I work, but definitely one of the greatest frustrations of FOIA today.
So in the law that has just passed, do we see potentially significant reform, major, minor? How does our panel assess what's just happened?
Well, the ACLU supported the bill. There were actually two different vehicles going through different houses of Congress, and each had something the other didn't. You know, the main thing, I think the highlight of the bill is that it creates this requirement that the government has to describe harm that would result from disclosure whenever it's defending withholding under one of FOIA's 7 exemptions. So I think on the face of it, that is very promising. The idea being that if you force the government not just to say that it meets certain criteria, but on top of that, that doing so will actually hurt an interest that's protected by FOIA's exemptions, that should lead to greater disclosure. And in combination with the new law's presumption of openness over most records, that should lead to more disclosure. The bad news, and this is also based on my experience, is that we already have a similar standard in the national security context because the executive order that the government is allowed to withhold things under as classified or national security secrets also has a harm requirement. And we find over and over again that courts are extremely deferential to government agencies' mere assertion that harm will follow. And that's in the face of a standard that requires describable harm. So you should have to lay out exactly what would happen, even if it's in secret to a court. And even without that, the government often gets away with just saying, I affirm as ex-FOIA officer in the CIA that the release of this information would cause damage to national security. The courts stamp it okay. And so in practice, that doesn't really amount to too much leverage. Of course, we'll be arguing that the new will of Congress is that this should be followed by the courts, and so we'll certainly be citing it, and it is the law. So I think that is something to look forward to. There's a time limit now on certain exemptions that the government can claim that should help in more historical research circumstances. When you're looking for things older than 25 years, you might be able to get access to that even if it had a still valid claim of exemption. And then, of course, I think for regular people and even for big organizations like the American Civil Liberties Union, There's a new FOIA portal. It's supposed to kind of move a lot of this online so you can track where your request is and actually get a lot more updated information about where things stand. And I think for citizens, that's a very positive move, and it's certainly something the legislators cared a lot about. But it remains to be seen how effective that'll be in terms of actually release of records.
Now, you live you operate in a very kind of specific area, and I think one can imagine why the government would be fighting about, what's the super secret targeted killing program and how does it work. But Talia, you've operated in a much less controversial area. I'm just curious, do you have FOIA PTSD? I mean, if you were, if somebody came in with a tip tomorrow and said, I got this great idea, it's going to take some FOIA requests, would you be more or less interested?
I don't think that it would deter me either way. I think that usually what ends up happening is if they say that it will require a FOIA, I will say, is there a way to do this without a FOIA first? And I mean, I think that's, I was thinking just when you were talking about the portal and all the other things, it's like, that's great, but I mean, it's also nice to have that one person whose email you actually have that you can say, I will continue to email you all day until, like, as opposed to this portal that is just, like a website, essentially. I mean, because there are plenty of agencies now that have their own websites that kind of track where your thing is, and that happened to me the other day. I'm like, well, my request was supposed to be finished on March whatever, and it is, now not March, and where's more of my documents, and there's no recourse there. But no, so it wouldn't deter me either way. I think that what we end up doing a lot of times is we will say, okay, we're going to put in this FOIA so they can get started and start cooking, and then we're going to try to find this another way. Maybe there's a person we can find, maybe it's somewhere already out there in the world, but we'll try to kind of get at it in a number of different ways, because even if you put in the FOIA, there's no guarantee that you'll get it in time, or that you'll get it when you need it, or that you'll get it in the way that you need it. So,
Sarah, what do you think? Deterrence or indifferent? What?
I just think it's what you do. I mean, it's kind of, it's a habit. Sure, I would love to try to get it some other way, but we have also found that that's becoming increasingly difficult. One of the things that's really happening is that you can get anonymized data through the open government portals and through some of the open government work, and especially statistical information, incredibly easily, that can kind of get us started until we can get the actual records that we need. So there are ways to get started before your FOIA is in, but no, I just assume that we're going to have to do that and that it's going to take a while. The one thing I do think is really helpful in the law also is a strengthening of the Ombudsman's office. And that is really important, because if you go back to the idea that this isn't a matter of somebody wanting to thwart you, most FOIA officers, believe it or not, are in that job because they believe in the public's right to access. And it's their difficulty of getting a straight answer either from their computer systems department or from the managers whose records they're trying to search, or from the program offices, or even sometimes from the White House, that they are kind of just stuck in limbo themselves. And so this idea that the Ombudsman's office can help step in and force them to find out whether the records even exist is really helpful.
Right, because, go ahead, Rebecca, sorry.
I just have so many responses to everything that was just said. Okay, in terms of the new law, it's encouraging because now we're amending FOIA, and we should keep doing that. And all of these steps are good. In terms of the portal promises, every single year there's some new FOIA portal promise. There's all these half-done portals. There's all these different ways to look at portals. There's FOIA Online that does federal and local stuff. New York City, everyone who lives in New York City, if you check out the mayor's office online FOIA portal, or FOIL here, it's not great. I encourage you to use it all the time, and just keep pushing it. But these portals are not good. And then as a matter of course, emailing folks, the people in government would rather have you, if there's somebody that can give it to you and they feel it's above board and they don't have to go through the entire FOIA workflow, they'd rather just email it to you than go through the FOIA workflow. So you're actually doing somebody on the inside a favor. But as a matter of course, everything you ask for, if it can be structured or something, make sure you ask for the Excel spreadsheet. if it can be anonymized, start asking for hashing, like, in your request. Like, these are things, like, if you've seen any sort of precedent for any sort of, like, formatting, just, like, as a matter of course, like, do that. And then also, like, we know FOIA takes forever. You keep a spreadsheet. You, like, constantly do it. You blog about how long it takes. Like, all of these things are, like, tedious as hell, but, like, when they're helpful. They're all, like, we need all these folks doing it as much as possible. How many folks in the audience have filed a FOIA request?
A lot.
Everyone should. Everyone that has not done it yet, you should just find something that you're interested in and start, like, exercising your rights and see how it goes.
Can I just say one
Jump in,
thing?
sure.
The one thing I would say is that for journalistic purposes, anonymized information really isn't adequate. And there has been a growing perception among agencies and officials that the mere disclosure of a company or person's name is some kind of major violation of privacy, which really is not what the standard is. And so, for instance, the health data that has been through the open data portal has been really very disappointing until the Wall Street Journal and the Center for Public Integrity sued to open up doctors' names in it. So the anonymization thing I would push back on from a journalistic purpose. If you're just looking for statistical information or trends, you might be able to get at it. But a lot of times what matters is how many times has the same company or the same person done something, and you can't do that with the anonymized data. So I just wanted to push back against that a little bit.
Sure. I mean, throwing this out to the panel, I've always felt there's a tremendous conflict of interest here. I mean, you have a law that says essentially we are entitled to information within 21 days, and then you have a government that's supposed to appropriate money sufficient to have the number of employees that would be necessary to fulfill the law, which will embarrass them. Amazingly enough, they never appropriate enough money to do this. And I guess the question I would ask is, how do we, as people who sort of are the surrogates for the American people, make a political case in favor of this? Because I honestly think at the moment, nobody feels any political pressure to fix this. I mean, sure, the Pentagon can have 5 FOIA officers, why not? Who's going to complain? How do you make the case to people that this actually matters?
I think it's just by doing good work. You know, when you can come out with a journalistic piece or file a lawsuit that results in the release of important records, it's incumbent upon you to make the case for FOIA at the same time, that revealing that that is the basis of how you came to this information, and explaining to the public the pretty intuitive notion that more information leads to better policy and more accountable decisions from the government.
I would say they take the opposite. I mean, to do that, but also make it too expensive for them not to have enough money. One of the changes in the new law, and I'm not sure how it ended up, you might know, Brett, had to do with attorney fees when you win. And I believe that they're much easier to get now when you win a lawsuit if this ball goes. And I don't know what the final one looked like. I know at one point it had this in it. But suing and getting attorney's fees back, when it starts costing the government more to fight a lawsuit and lose than it does to fund the offices, that's when they'll decide it's worth it.
Remember, they are spending our money to pay those fees.
It's the same, you know,
They're happy
one
to
or
do
the
that
other, yeah.
usually.
And the lawyers that are litigating on their behalf. But I mean, I think it is kind of an unfortunate reality of the FOIA process that when you do have resources like the ACLU or the New York Times, I know Dave is definitely not shy about filing lawsuits,
Right.
neither are we, it does bring you to the top of the list, and it does allow you to negotiate with somebody who has some decision-making authority about when they will roll out records, how they will conduct searches, answering your point, kind of discussing language that will help narrow the request that is both acceptable to the requester and feasible in terms of implementation. And it just is a tough reality, and I think we take that seriously. You know, we know that when we're in court fighting for certain documents, we know that the law we make in there is going to affect how the agencies behave down the line, even without lawsuits, because once the law becomes clear, hopefully everybody can benefit. But it is a strange truth about it.
One of the things I worry about a little bit, I mean, when we started ProPublica, which is a nonprofit journalism organization, we made this argument that the sort of field of investigative reporting was the result of newspapers' outsized monopoly profits, and when those profits disappeared, you'd see less investigative reporting. I think there's some truth in that. But the other thing we see, which I'd love to hear everybody's opinion on, at the local level, those monopoly profits funded the records fights in the states of Oregon or the state of Louisiana or the state of Washington. You know, it was those papers, you know, the Times-Picayune, the Washington Seattle Times, Oregonian Portland, going to court and fighting those fights because they were very profitable. And it was, of course, in the public interest. One thing I think you can be certain of if you're a state bureaucrat right now is that no paper is going to sue you. And I think that's emboldened people, and I'm not sure there's anything out there filling the gap.
Well, I would. Who was the reporter who shook loose from? I don't know what happened. I'll try this one. He's the reporter who sued the Chicago Police Department to get the Laquan Williams tapes of his shooting, and he did it with the help of a nonprofit pro bono lawyer. And in, I believe, 20-some states, there are lawyers who will take journalists' cases on spec because they can get legal fees back. And you're seeing, while I totally agree with Steve that you can count on the papers not to sue anymore, there is kind of a growing network of people like the people in this room who feel strongly about an issue and are willing to fight the government on their own, and also with the help of other nonprofit news organizations that are state-based.
So at the local level, one of the interesting things we've seen, like as a reaction to Flint, there's some, I don't know where this is at, in Michigan, but you couldn't access the governor's email. And they were like, oh, there's a scandal, we need to see the governor's email. In certain states, you can see the governor's email. There's legislative action there. We've also seen, as a reaction to some of the police data stuff, again, another Illinois case, Calvin v. Illinois, is this push to make disciplinary files like not strictly totally private, but sort of like this quasi semi-private zone. But I think, I don't, half glass full. I feel like a devil's advocate or something on this panel, which is not usually my stance. But I think modern America, you expect information as a result of something, and as we have more issue areas, and I think the police data thing is like a prime example of this. Like we have this very charged, obvious social issue. And the question keeps being like, where's the data? Why aren't you collecting the data? Why doesn't DOJ have the data? Oh, DOJ settlement, more data requirements. How do we FOIA more of this data, et cetera, et cetera? And I think like as we have more issue areas, it's going to be more obvious like where's this information that's attached to it. And I think we're going to see a lot more local FOIA amendments as a result.
I think that in addition to kind of working with different organizations like for pro bono legal services, you may end up seeing a lot more papers or investigative reporters partnering with people who have the data, who have taken the time to either file those requests or to just go through that legal process, and they come to us and say, hey, I have this stuff and it's valuable. I don't know what to do with it. Maybe you can do something with it. I mean, this is the age of the whistleblower now. So, I mean, if you can get data even from, official channels and give it to someone who can, put it in a better form and figure out what it actually means. And I think you might see a lot more of that, where there used to be much more of a, we're the paper, so we can do this on our own. And it's like, well, no, okay, we're kind of all citizens now. And let's figure out how to work this together, because the system is so hard to navigate.
I would be delighted. I see a hand up. I'd be delighted to take questions. And so let's start with one. I guess you should identify yourself and state your question.
Anthony Liversidge, Science Guardian. Could I ask, to what extent can you take advantage of the fact that a FOIA has been filed on a topic that you're interested in and succeeded? Can you then get a duplicate given to you? Is there some kind of listing of ones they've answered?
Yeah, so generally, The way FOIA works is they do release records to the requester, but then they should be available to anyone that files a request after that. You know, the ACLU's practice and many news organizations too is to post the documents they receive online, whether you've dealt with them in a blog post or a lawsuit or any other kind of a way. But certainly under the law, if something has been made public to another requester, the government has to give it to you if you ask for it.
And there are a couple places, a couple of agencies that are using the FOIA portals to post everything that they release.
Right. There wouldn't be a government-wide one. We'll have to wait and see if the new law has any kind of effect to centralize some of that stuff. But certain agencies will post things like that. Weirdly, the intelligence community has been posting on its own the things it gives to FOIA requesters about NSA surveillance on a dedicated website. The Office of Legal Counsel, for a long time, I won't say they really keep this updated anymore, posted their public decisions there so you didn't have to go out and ask for them. And I'm sure there are many other agencies that do, at least with selective releases, but not as a government-wide practice. I don't know of anything like that.
Just one more thing, the new law requires them to post anything that's had 3 or more requests.
Right.
Yeah, so local governments do this too. So it's like certain federal agencies, and then a variety of different tools are out there. And then also, like, even if you aren't a government institution posting something online and someone requests it, there's these organizations that do that if you contribute to their service, like Muckrock, FOIA Machine was like a thing back in the day. I don't know if folks are still using it. But there's a variety of, like, it's a best practice to post things online, whether or not you're the Washington Post and you're posting it online, or you're some sort of like activist. But it's agency by agency. It's agency by agency in New York City. But like some cities that I'll shout out to are like Seattle, Oakland, Albuquerque is going to start doing some things. But these are all, like, there's some local action to proactively post things online. And then there's certain services, so like there's something called Record Track that's now called Next Request, where you can actually see when something is posted online how many times it's downloaded. And you can see, like, some documents have been downloaded like 36 times, which could imply that there's public interest in this document and that you have cost savings. And for what it's worth, too, if you go to foia.gov/data, they've been keeping data on requests for the last, I don't know, 4 years or something. But you can see that actually federal requests have gone down. Backlog hasn't necessarily gone down, but we keep metrics on this. But at the local level, metrics are not necessarily kept. So federal or local governments don't even know, are our FOIA requests going up? Are they going down? Are we meeting demand? This sort of thing. Basics that everyone should be doing. And there were some laws in New York City recently to post everything online that was foiled, did not pass. And also there's like a metrics law did not pass.
New York is not great, as it turns out. We've been doing some local reporting lately at ProPublica. It's really not great.
For what it's worth, at least this legislation being introduced is not super common, so at least something was introduced.
Okay, what do we have? A question in the back? Sure.
Hi. My name is Emily Hopkins. I'm currently working at the Marshall Project. The rest of the time I live in Massachusetts, which is known as one of, if not the worst, FOIA states in the country. So I'm very familiar with some of the frustrations that you guys have felt. My question is that I find that more and more private companies, and especially private tech companies, are getting involved in private-public partnerships with cities, and that some disclosure agreements are baked into these partnerships where they're sharing data, but they explicitly say in the agreement that that data is not FOIAble. I know that's mentioned in Boston's agreement with Uber, probably other places as well. And I understand that ShotSpotter also has a really tight hold on its data. So I'm curious to know what your thoughts are on the future of all of this really valuable, should be maybe public data that's being held in private company as trade secrets.
Yeah, in some states this has been challenged. So it started out with a thing on crime data that some cities were giving over. I forget what the name of the site was, but basically the site would help them figure out how to keep their police incident data which was? Something like that, yeah, I think. And there was some case law that they were trying to write into contracts that they were basically taking public data and making it proprietary. And in a couple places where they were challenged on that, they were overturned. So I think that there is some opportunity to overturn those contracts. You can't really give away public data, right? And that was shown even in New York State a long time ago when the old tax maps, the GIS information, was supposed to be proprietary because it was so expensive to put together, and in New York State, they overruled that. So there has been some challenges on that, and it probably was going to have to just shake out.
Yeah, I mean, I'm not that familiar with many of those. The one context I am familiar with NDAs is in the Stingray context. Stingrays are surveillance devices that police can drive around through neighborhoods, and they basically ping all the cell phones in the neighborhood and bring back information about where these people are, what the phone numbers are, sometimes even can collect text messages that are flying over the air. And a lot of this was FOIA'd, and the way that the NDAs were revealed was not through FOIA, it was actually through criminal litigation when police departments would go up in front of a judge and defense attorneys would say, well, how did you get the tip that led you to this suspect in this neighborhood? And they would say, well, it was an informant. And then they would start asking questions about the informant, and then they would say, eventually they get to the end of the line, they say, I can't talk about this because I signed an agreement not to talk about it. This first happened in Florida. A colleague of mine has written about it, and it became a big story there. And it actually led to a lot of publicity and movement on the issue. That obviously is in the context of a criminal trial, and where you have a constitutional right to confront evidence against you, it's far more problematic for the government to be saying we signed an NDA than even in the FOIA context. But I think the principles are pretty similar, and I would wait out the results of some of this stuff because it doesn't seem right, and I think that in the end it probably won't be.
Sure, up front.
I have a very loud... One moment. Is it okay?
I think it's for the streaming.
So it's a very simple question, but I'm not sure that the answer is quite simple. What do you do when a government agency has claimed that it has no data on a specific issue or question?
Well, there's a number of different things you could do. I guess the first thing is to look and see what records they actually do keep. Because they have to have a log of, well, not a log, but basically a list of what they have, where they keep it, things like that. So then you can say, okay, let me try to figure out how I can, no, so that doesn't exist apparently. Okay,
great list.
But there's
Looking forward to that list.
I guess I'm thinking about the records retentions list. That's what I'm thinking about. Because if you're looking, it's a list of how long the government has to keep something, a particular piece of data. And so they can say, okay, after 5 years, I no longer have to keep this, for example. So that can be a start. So if you say, okay, you know what, I need, X piece of data. Is it in this record retention list? And then you can say, okay, I know that you have to keep it during this period. So then you can kind of say, this is an avenue to get me in here. I think that's one way to do it. I think also trying to, so I don't know the system all that well. I usually end up using people a lot more. So I will go and find someone who I've talked to before, someone who used to work for the agency, and say, hey, I'm trying to get this thing, or advocates who work in that industry who are experts in that thing. And I say, hey, I'm looking for this thing. Do you know where they keep this? How should I actually structure this? When I'm asking them, so what are the words that I should use? And I will we did this for the OCR, or the Office of Civil Rights story. We were like, okay, what is the actual language we need to use to make sure that we are asking for the proper things? Because it may be that the government says we don't have this thing that you asked for, but what the information that you actually need, they do keep, but they call it something else. And so that's where, a lot of what we do is just kind of making sure that we're asking for the correct word, essentially.
Yeah. Oh, go ahead.
In the federal space, there's also something called SORNS, the System of Record Notice. That's like something you can cross-check against. But again, I've talked to folks like Jason Leopold, FOIA terrorist, talked to him a bit about how his experience knowing the structure of an agency better than the agency knew it itself, because he had just done so many different FOIA requests and asked so many different questions and sort of reverse engineered it through a variety of questions. It's very possible one, the data actually does not exist, and think about that, and then also just like reframing it, like how did you put it, or like did folks not find it? And then I'm going to accidentally answer the previous question too, to the contract language. Like, so my organization now at Johns Hopkins has some example like data rights contract language. We actually work with Reinvent Albany, a good government group in New York State, to create that language. But the data access and rights, especially when it's structured like that and it's like Uber and it's super useful, and I know it's just going to be proprietary. You can't FOIA it, you can't open it. Crime Spotter's another one on top of ShotSpotter, but there's an Esri to some extent. Like all of these organizations, these big powerhouse that like every city has procured from, keep rights to the information. Email me. And also, like, city council should be passing things, and procurement offices should have just provisions. It's like up to your local government to write in a provision that says, Uber, if you're in your town, you have to release the data here. And this is exactly what the language looks like.
That's very useful. Here.
Just one more tip that I got from Jason Leopold is to request the processing notes from your FOIA. FOIA yourself. And so what you do is you ask for the processing note for your case, and it will tell you what they searched and how they searched it and what they searched for. This is a real problem in the FBI if you don't know exactly which field office and which system of records to search. So getting the processing notes on yourself is really useful.
Hang on, good. Sure, go ahead.
Answers on a particular topic. Can you say about Mr. XY, have you answered any FOIA, do you do that? Do you, in fact, ask
No, I usually don't, but I mean, what I will do is look at the FOIA logs and see what experts on the topic and on the thing are asking for. So I usually I'm not that specific usually. I'm not usually looking for something that specific, but yeah, you can certainly do that.
Right here, in the middle.
Thank you. I've been curious. I think there are at least two categories, right? There's kind of not-for-profit, and there's commercial use. The company I work for, in my last company, I made a lot of FOIA requests. I made one recently, this was to Amtrak, and they just lumped me in the commercial bucket. I didn't state any affiliation. I didn't put my company name, and I could have pushed back, etc. But more to the question is, why this idea of charging parties? Are the commercial parties are somehow going to take advantage of this kind of public resource, and somehow if you're not-for-profit or journalist, you're allowed to do that? It's kind of, I think, an unsavory way of almost kind of discriminating against a party for no good reason that I can understand. I don't know if anybody can speak to that.
I mean, the history of it is that the commercial requesters have to pay the cost of actually doing it, and that they're saying for in the public interest, we will let the taxpayers effectively subsidize it. So it's not so much that like these other people are getting, it's more like that the public interest people aren't paying their cost, and it's that because it's the public's data, they will do it, but if you're doing it for purely commercial purposes, you have to pay the actual cost that they incur. But that's the history of it. I'm not sure what the practicality of it now.
Well, while we're talking about that, Sarah and I were recently at the convention of the investigative reporters and editors, which gives something called the Golden Padlock Award to the government agency which does the best job of withholding information. And Sarah, I'm going to get this wrong, but I'm hoping you remember it. There was a Pentagon request, I believe, that they said which Veterans Affairs won, but the Pentagon was asked for some piece of data and informed the requester, which was a journalism organization, that it would take something on the order of 670 million man-hours and $10 billion. So we too get hit by records requests with charges. So it's not unique to. I mean, how does one deal with that? Because you do get this business about, sure, we'd be happy to give you your information, but it's going to cost you a little, say $500,000.
Sure. One of my colleagues is actually dealing with this right now, and they keep coming back with more and more fees and more different things. We basically just keep going back to them and saying, no, number one, we're a media organization. Two, this number is ridiculous. And I think that right now she is currently FOIAing the salaries for all of the people in the office who will be required to produce the information, because it's like, okay, who are you paying, $100 an hour to do this? And if so, then that's our story.
Why isn't
So,
that
yeah.
already public? I feel like that should already be public.
Well, it may not be, but we're looking for it. So that's what we're doing. So, but basically, we just keep going back, and I just know that she's involved our lawyer, and so it's really, we just try to go at it from a number of different angles. And I guess we're kind of hoping that if we do the FOIA, it's like, okay, they're really serious. Let's just go ahead and give this to them.
Yeah. They are fairly stingy on handing out the public interest, and I think your comments were right on in terms of what they're looking for. One thing that'll take you out, even if you are a nonprofit, will take you out of that category is if you are doing something in your own commercial interest. So that's a standard that they look at. I mean, even the ACLU runs into responses at the agency level where they say we're not working in the public interest, or we don't qualify as a news media requester because it's not clear that we plan to disseminate the information when we can cite like 100 things that we have online that have only our FOIA documents. So it is certainly something that we keep running into. We never actually get to the point where in litigation it becomes an issue, because if we ever sue an agency, they stop saying that.
I was just going to say business interests are supposed to be the whole, they're one of the main points that people love the open data stuff. So like you have a big argument, especially if you're doing like continued requests, that this should be open data to begin with. But then in terms of how much things cost, I would just keep asking information about why it costs that much. Like, are you printing it? What are the redaction hours? What IT systems are you using? Because there's stories there. That's like 3 stories I just gave you, and they're good stories, and I would read them.
Excellent. Time for one more question.
Yes, just coming back to New York City and looking at the FOIA requests, are you anticipating any new changes in the law statewide regarding freedom of information? And if so, what would possibly be some of the changes? No?
Go to Reinvent Albany. Google Reinvent Albany. I don't know what's up with New York anymore.
Yeah, I wish I could say more. I mean, if there were any corruption in the state or city of New York, I suppose there might be a movement in that direction. I don't know how many more leaders of the legislature we can put in jail here. It's preposterous. We at ProPublica have done some work in the arena of, rent stabilization, and the things that have been withheld from us are absolutely clearly within the orbit of public interest information. And so far, our only luck, frankly, has been to develop sources, confidential sources who provide us with material, because we are unable to get the things that, our lawyers are telling us we are totally entitled to. So I don't know. This is my first sort of deep experience in the last about year working on New York City stuff. And frankly, as a Massachusetts native, I'm not sure we want to, cede anything to Boston here. I think we are really excellently awful.
I'll add one thing. One of the things that we see a lot in New York State, which is really frustrating, is that the FOIA law itself is not that bad, but that every time there's a new law put in, it exempts itself from FOIA. So I know that's the case in the rent stabilization issue. It's also the case with some of the disciplinary records. It's happening all over the city. Even worse in New York City is the law actually isn't that bad. You can sue and win in New York City and still never get the records, which is what happens more and more. And to me, it's public pressure that's gonna change this. But it is. I used to joke that I thought that Maryland, Virginia, and DC were bad. This is at a whole new level.
All right, we've almost become a gripe session. Thank our panelists. And thank you all for coming.